Is my spouse going to get all my money and assets? Clients ask me this question all the time. That's completely understandable. Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham region and the GTA. In fact, my client Danny was really worried that this might happen to him. His wife threatened to take everything he had if he did not agree to what she wanted. Luckily, Danny came to see me before he signed anything to get proper family advice. I told him that no spouse, including his wife, gets all the money and assets in a separation or divorce. Let's be honest. Money does not mean everything in your life. And having more money is sure a lot better than having less money in your life. That's for sure. You need to understand some of these critical facts about money and assets in your separation or divorce in Ontario. When you're married, you can make a property claim under the Ontario Family Law Act. However, you cannot make the same claim under the Ontario Family Law Act if you've been living in a common law relationship with your spouse. When you make a property claim under the Family Law Act, you must determine or figure out your net worth, that is your assets minus your debts, on the date of separation. You must provide a detailed financial statement to your spouse that lists your debts and assets. Your spouse must calculate their net worth as well. They must also prepare a detailed financial statement that lists their assets and debts and provide it to you. You and your spouse, in other words, must both provide full financial disclosure to each other to work out your property claim in your separation, divorce, or family law case. This means you must provide full proof and documents that show the value of your assets and the amounts of your debts. Your spouse must provide the same proof to you as well about the value of their assets and the amounts of their total debts. Based on the property formula in the Family Law Act, the spouse with the lower net worth on the date of separation is entitled to half the difference between the two net worth calculations. For example, let's say your spouse has a net worth of $250,000 and you have a net worth of $100,000. When you subtract $100,000 from $250,000, you have a difference of $150,000. And half of $150,000 is $75,000. Your spouse must pay you $75,000 in this example so that you both have the same net worth of $175,000 after your separation. This payment of $75,000 is called an equalization payment since it equalizes both spouses' net worth. Now, if you're unmarried and you live with your spouse, you're entitled to keep the property you brought into the relationship and the property that you purchased during the relationship. If you have significant financial or non-financial contributions to the common law relationship, you can make a claim against your spouse's property, such as the home that is in their name alone. For example, if you pay part of the mortgage every month, you should be compensated for these important financial contributions. You can make what is called a constructive trust claim against the property. You can also make a constructive trust claim when you have made significant non-financial contributions, such as domestic work and raising your children. If you have any questions about your separation, divorce, or family law case, and you'd like our help, feel free to contact me on my Facebook Law Office page, that's O'Malley Family Law, or call me at 905-434-8837, and I'll point you in the right direction. Please make sure to share this important information and video with your friends, family members, and coworkers.